Good morning and welcome to the January 28th, 2026 meeting of the Texas Commission on Environmental Quality. The time is 9:31 a.m. For the record, I'm Chairwoman Brooke Popp, and with me today are Commissioners Katarina Gonzalez and Tanya Miller, our General Counsel Mary Smith, and our Public Interest Counsel Garrett Arthur. For each item, the argument and discussion is allowed. We'll inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please visit our registration table, or if you're virtually, email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on. We'll do our best to accommodate that request. For those making presentations, please wait to begin your presentation until Mary or I have asked you to begin speaking, and please check to make sure that your line is unmuted before proceeding. Tanya, do you want to welcome your new SA before we get started?
Oh, sure. Welcome Kevin Patterson back to the agency. Some of you may know him. He worked for former Chairman Shaw and has great depth of experience in these issues. So welcome, Kevin.
Very happy to have you. Thank you. All right, Mary, first item.
First item is Old Business 1. It is the consideration of the petition filed by Sunny Jane Elizabeth Ahrens and Thomas Edward O'Kelly for the creation of Kelly Farms Municipal Utility District of Johnson County. This item was continued from the November 19th agenda, and at that agenda, the commission agreed to continue the item and invited the parties to present oral argument. So we will first have the hearing requesters, Luann Langley and Johnson County Commissioner Woolley. They will collectively have 6 minutes. And then we will have petitioners, Sunny Jane Elizabeth Ahrens and Thomas Edward O'Kelly, who will collectively have 6 minutes. And then the ED and OPIC will each have 5 minutes for their presentations. And the hearing requesters, Luann Langley and Commissioner Woolley, may reserve time for rebuttal. So with that, we'll begin with the hearing requesters. We'll call Luann Langley first. And I believe she's virtual.
Langley, can you hear me?
Can't hear anything here. We'll go on to Commissioner Woolley.
We're going to give this a second.
Yeah. It seems like we have.
For some reason, I'm muted and I can't disable that.
Okay, now. Here.
Can you hear me now?
We can.
Okay. I'm Larry Woolley, Johnson County Commissioner in Precinct 4. I do have some concerns, serious concerns about this development, and we are some of the requesters for a contested case hearing. First of all, water is very limited availability on the east side of I-35. I've talked to our Johnson County Special Utility District, and I'm understanding that there's some concerns and some difficulties in acquiring water for this development. Moving on, our next concern would be the strain on first responders. We do provide a EMS service in Johnson County, and in discussion with our provider, which is CareFlight, the CareFlight Ground and CareFlight Air, that development could potentially require an additional unit. That would be about a $500,000 burden on existing taxpayers. The Greenview Volunteer Fire Department is based up of all volunteers. They're funded by our Emergency Services District. In the event that would potentially require paid firefighter or paid first response individuals there, that would also create a tax burden as well. Sheriff's Office is potentially also going to be impacted as first responders in that development. It's our understanding that this development has 1,950 homes potentially to be built in there. County Road 203 is on the east boundary of that development. It's 1.8 miles. It is in substandard condition now due to the lack of any development in that area. In the event that there was development, that would require a total rebuild and then probably another rebuild upon completion of that development. Somewhere in the neighborhood of $250,000 in expense for that. County Road 106 up on the north side was a recent rebuild. It would likely have to be rebuilt after construction traffic was done there. I've also been asked to share some concerns from the Greenview Independent School District Superintendent, Mr. Kirby Basham. He asked me to convey their concerns that this development could result in potentially doubling their enrollment. Their current enrollment is 1,400 students. I'm a former school administrator in that district as well, have a very good knowledge of what goes on there. That district is limited in its capability, bonding capability. This would create a undue strain on taxpayers, and in Johnson County, school bonds seldom pass. This could be
3
disastrous
minutes.
for that school district. I'll relinquish my time now to Ms. Langley. Hopefully she's unmuted and can give some environmental concerns.
Thank you. Ms. Langley?
If she is unable to respond, or is there some time left? If she's unable to respond, I can share with you what some of her concerns were.
That's fine. Go ahead.
Ms. Langley is a nearby landowner and resident in that area just east of this potential development and is familiar with that property currently in farmland. Land application of biosolids has taken there in the past. We have just east of maybe a mile or two east of this property, we've done some extensive testing and have found alarming levels of PFAS contamination in the groundwater, surface water, soil, tissue samples in beef cattle and fish. The land application that's taken place on this particular property here could also be contaminated with PFAS chemicals. That's a major concern whenever it comes to a residential development, not only for the residents, number one, but number two, the runoff that would ultimately result in that wastewater going into Chambers Creek, which feeds into Richland Chambers Reservoir, which provides drinking water for a number of Metroplex cities, including Fort Worth and Keller. That is one of her major concerns and ours as well. So I would hope that the commission would take that into consideration as well.
Thank you very much.
Thank you very much.
Okay, and then we have Brian Moore for the petitioners.
Good morning, Mr. Moore.
Good morning. Good morning, Chairwoman. Good morning, Commissioners. Good morning, General Counsel. Good morning, Public Interest Counsel. I'm Brian Moore with the law firm of Coates Rose, and we represent the petitioners in this matter. I have had the honor and the privilege of appearing before this commission for over 20 years. The matters have been many and they've been varied, and I don't claim to remember them all with absolute clarity. But I do believe that this is the first time that I've ever appeared before this commission at agenda to give oral argument on a hearing request. And while I appreciate the opportunity to be heard, while I appreciate the opportunity for my clients to be heard, I must confess that I am at a bit of a loss to understand why the commission requested oral argument on this particular petition. The 3 hearing requests on this petition are typical of countless other hearing requests that this commission has routinely processed for years without taking any oral argument. It would appear that a false equivalency was drawn at your November 19th agenda when you were originally scheduled to consider the hearing request on this petition, as well as hearing request on 2 petitions to create MUDs in Williamson County. Instead of deciding those hearing requests on the briefs in November at agenda as originally scheduled, you rescheduled all 3 matters for oral argument in December. Then you rescheduled them again for oral argument today. Well, those Williamson County MUD matters, they're no longer on today's agenda. But since Williamson County was the only hearing requester in those other 2 district petitions, I assume this commission scheduled, then rescheduled all 3 matters for oral argument at the same agenda because you wanted to hear argument on a county's effectiveness in district creation cases. Well, perhaps today's argument would have been a bit more enlightening had those 2 Williamson County matters stayed on today's agenda. But sometime after the second postponement, Williamson County withdrew its hearing request, which left only this matter for oral argument at today's agenda. Apparently, my client's petition was joined at the hip of those 2 Williamson County matters because an individual county commissioner, Commissioner Woolley, who you just heard from, he requested a contested case hearing on our petition, and Commissioner Woolley's hearing request, I believe, was falsely equated to the ones that were filed by Williamson County in those other 2 district creation matters that you were scheduled to hear today. Well, Commissioner Woolley's hearing request on the Kelly Farms petition, the petition that we're here to talk about today, that hearing request is decidedly different, markedly different than the hearing requests filed by Williamson County in those other 2 MUD matters that were previously on today's agenda. If the commission would have taken up Williamson County's hearing requests on those other 2 matters, if you would have taken them up today, the commission would have decided whether the various statutory authorities that a county may have and may cite under state law, whether those authorities alone are sufficient to demonstrate that a county is an affected person in MUD cases with respect to a petition to create a district within the county. The commission necessarily would have decided that issue if it would have taken up the Williamson County requests, the hearing request, because that was the issue, the only issue presented by those Williamson County hearing requests. That issue is not raised in Commissioner Woolley's hearing request on my client's petition. It simply is not. As the executive director and OPIC both noted in their briefs, Commissioner Woolley's hearing request does not assert or even reference Johnson County's statutory authority over anything in any way whatsoever. So if it was the commission's original intent to make new policy today regarding a county's effectiveness in district creation cases, then I would respectfully submit to you that Commissioner Woolley's hearing request should have never been set for oral argument. Commissioner Woolley's hearing request on the Kelly Farms petition does not state that it was filed on behalf of Johnson County.
That's time.
Thank you. I'll wrap up and say Commissioner Woolley does not even allege that he has been authorized to request a contested case hearing on behalf of Johnson County. Thank you for your time.
Thanks, Mr. Moore.
The ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Office of Public Interest Counsel. I am Kayla Murray, an attorney in the Environmental Law Division, representing the Executive Director. With me is Justin Tack, Manager of the District Section. The ED affirms her position as stated in the ED's response to hearing requests for the creation of Kelly Farms MUD of Johnson County. To summarize that position, Luann Langley did not identify how she would be affected by the application with respect to an issue that the Commission may consider as part of the review of a MUD creation petition. Her concern about water quality impacts is more appropriate to raise in response to an application for a wastewater discharge permit instead of a MUD creation petition. Her remaining concerns are outside the scope of what the Commission may consider for a district creation. Commissioner Woolley's listed concerns were also outside the scope of what the Commission may consider for these types of applications. Additionally, Commissioner Woolley's request did not identify the county's statutory authority over or interest in issues relevant to the application as required for a hearing request from a governmental entity. State Representative Kerwin withdrew her hearing request last week. So in conclusion, the ED requests that both hearing requests be denied. Thank you, and we are available for questions.
Thanks, Kayla.
OPIC.
Good morning. Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. The Commission received requests for a contested case hearing from Luann Langley, State Representative Helen Kerwin, and County Commissioner Larry Woolley regarding this application. Representative Kerwin has subsequently withdrawn her request. OPIC reiterates the position taken in our brief and respectfully recommends that the Commission grant the hearing request of Luann Langley. Ms. Langley's request states that she lives approximately 1/2 mile from the proposed district boundary. This proximity was confirmed by her location on the map created by the Executive Director's staff. Ms. Langley made timely public comments in a hearing request that raised some issues within the Commission's jurisdiction, including water quality and runoff. According to Texas Water Code Section 54.021B3, unreasonable effects on natural runoff rates and drainage, as well as water quality, are factors the Commission shall consider when determining if the project associated with a petition for creation of a MUD is feasible, practicable, necessary, and a benefit to the land to be included in the district. It is OPIC's position that Ms. Langley's specified concerns, in combination with her proximity to the proposed district boundary, give her a personal justiciable interest in this matter which is not common to the general public. Additionally, her concerns are interests protected by the law under which this application will be considered. A reasonable relationship exists between those interests and the regulation of a municipal utility district, and the location of her home increases the likelihood of impacts to health, safety, and use of her property. Furthermore, Ms. Langley filed a timely reply specifically reiterating her concerns about potential effects on water quality and runoff. In this reply, she further specified that her concerns were related to the creation of the proposed district itself. For these reasons, OPIC recommends that the Commission find that Luann Langley qualifies as an affected person in this matter. Commissioner Larry Woolley made timely public comments in a hearing request on behalf of Johnson County. Commissioner Woolley's request articulated concerns related to traffic, increased enrollment in the local school district, and the amount of effluent released from a plant constructed in conjunction with this MUD development. OPIC notes that flooding is outside of the scope of the district creation petition, and any wastewater treatment plant constructed in conjunction with this development would be required to go through a separate Texas Pollutant Discharge Elimination System permit application process. Commissioner Woolley's other concerns are not within the jurisdiction of the agency. Additionally, Commissioner Roy submitted a reply to the ED's and OPIC's initial recommendation. However, this reply only reiterated the issues raised in his initial request and failed to include any discussion of issues within the scope of this petition for mud creation. OPIC cannot find that Commissioner Woolley nor Johnson County has demonstrated that they qualify as affected persons in this matter. For the foregoing reasons, OPIC respectfully recommends the Commission find that Luann Langley qualifies as an affected person, grant her request, and refer the matter to the State Office of Administrative Hearings for a contested case hearing. Thank you, and we are available for any questions.
Any questions for OPIC?
Yeah, I have a question. Her concerns, are they to the review of the mud creation, or is that more of an issue for the TIPD's permit?
It was our position that her concerns were related more to the district itself. She talked a little bit more in detail about that in her reply and specifically referenced that that was the relation of her concern. It oftentimes was in reference to nearby waterways and the effect that development in the district would have on those current drainage patterns.
Are those the drainage? Are those not relevant to the TIPDs? Because it seems like her other concerns are property values, traffic, housing density, which seem outside the scope of related to the creation.
Yes, I believe that several of the issues she raised in her request were outside of the jurisdiction and were unrelated to either the district creation or the TIPD's application, but I believe that her request did have reference to some of those statutory factors that are considered as part of that district creation language.
Thanks.
Thank you.
And the hearing requesters, Commissioner Woolley, you have 1 minute and 20 seconds remaining if you would like to make a rebuttal.
Thank you, and I appreciate this opportunity. First of all, none of our concerns had anything to do with the Williamson County issues. Number two, our Senator Phil King has requested a contested case hearing on the sewer treatment plant, and I understand there's the concerns here are twofold: the development as well as the sewer treatment plant. It's my understanding that his office has filed that request, and those are valid concerns as well. But this, Ms. Langley's concerns about the runoff, the drainage patterns, where that potentially contaminated runoff could end up, is a very, very valid concern. That's all I have. Thank you.
Thank you very much. All right. Before us, we have a petition for the creation of Kelly Farms Municipal Utility District of Johnson County with a request for additional road powers. After reviewing the hearing requests and listening to the arguments, I agree with the ED that the requesters failed to demonstrate how they would be affected by the district creation in a manner different from the general public that is within the Commission's jurisdiction. I'll pause right there and see where my colleagues fall on this.
Yeah, after reviewing the hearing request, I don't think the requesters should be found to be affected persons. I don't think they've met the requirements under the Texas Administrative Code.
I'm in agreement.
Since we are recommending the denial of all hearing requests, we must also consider the petition for creation of the district on its merits. Turning to that consideration, we have the petition and ED's technical memo detailing staff's review of the petition. The memo includes general information about the proposed district and engineering analysis, a summary of cost and bonds and economic analysis, and special consideration for road powers under Texas Water Code Section 54.234. From the information in the petition and this memo, it appears to me that the proposed district is feasible, practical, would be a benefit to the land within the proposed district, considering the 3 factors and 7 subfactors described in Water Code Section 54.021. that the petition meets all the other applicable requirements, and that the criteria for additional road powers are satisfied. I would also note that temporary directors put forth in the petition for creation meet the qualifications, so I would appoint them all. So colleagues, I grant the petition, approve the road powers, and appoint the 5 temporary directors included in the application and the ED's technical memo.
I'm in agreement.
I'm in agreement that they met all legal requirements for creation.
Is there a motion?
I move that we deny all hearing requests, grant the petition for creation of Kelly Farms Municipal Utility District of Johnson County, find that the petition satisfies all applicable statutory and regulatory requirements, and the district is feasible, practicable, and necessary, and would be a benefit to the land to be included in the district, that we approve the district's request for road powers in accordance with Texas Water Code, Section 54.234, and we appoint the following 5 people to serve as temporary directors until permanent directors are elected and qualified: M. Aziz Ba, Jeffrey Michael Lively, Joseph Margiotta III, Bo Weiss, and Darren Harbour.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Thank you. The motion passes. We will move on to the next item. Let everyone shuffle. I guess no one's shuffling.
No one's
Never mind.
shuffling, yeah. Old business 2 is the consideration for publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 293, regarding water districts. And the executive director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Justin Tack with the District Section of the Water Supply Division, and with me today is Kayla Murray of the Environmental Law Division. The proposed rulemaking would revise 30 Texas Administrative Code 29311 regarding information required to accompany applications for creation of districts, revise 30 TAC 29312 regarding creation notice actions and requirements, revise 29315 regarding addition of wastewater and or drainage powers and the conversion of districts into municipal utility districts, revise 29332 relating to the qualifications of directors, revise 29341 related to the approval of projects and issuance of bonds, revised 29359 regarding economic feasibility of project, revised 29363 relating to contract documents of water district projects, revised 29381 regarding change orders, and revised 29391 regarding reporting by districts. The rulemaking will provide consistency with amendments made to Texas Local Government Code Chapter 375 from House Bill 2815, and Texas Water Code Chapter 49 made by House Bills 1410, 2815, 3437, 3507, and Senate Bills 938 and 1397. Texas Water Code Chapter 54 made by 2815, and Texas Water Code Chapter 57 made by House Bill 2815. A public hearing will be offered on this proposal in Austin on March 16, 2026, and staff respectfully recommends approval to propose the publication of and hearing on Chapter 293 water districts. And staff also respectfully request permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available for any questions.
Thank you. Any questions for Justin?
No questions?
Mary, has anyone signed in on this item?
No one is signed in.
All right. Garrett?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. For the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed this proposal for rulemaking and respectfully recommends publication. The purpose of this rulemaking is to amend 30 Texas Administrative Code, Chapter 293, to implement HB 2815, HB 3437, HB 3507, SB 1319, and SB 938 from the 88th Texas Legislature, and HB 1410 from the 87th Texas Legislature. This rulemaking would have a myriad of effects on the public, including allowing members of the public to be appointed or elected to the board of directors of a newly created municipal management district, giving the public the opportunity to comment on and hold hearings regarding the creation of municipal management districts, notifying the public of a hearing on conversion of a district into a municipal utility district, and providing the public the opportunity to comment and review any pending litigation facing the district at that time. However, the public notice process is no longer required when a conversion application application is received by the commission, and requiring that members of the public seeking appointment or election to a levy improvement district meet the requirements of Texas Water Code Chapter 57. Regarding taxation, this rulemaking would have some effect on the public. Enacting HB 2815 adds Austin, Brazos, Liberty, Grimes, Wharton, and Walker counties to the list of counties where the maximum projected tax rate is $1.50, and adds Bastrop, Bell, Blanco, Burnett, Caldwell, Gillespie, Kendall, Lee, and Milam counties to the list of counties where the maximum projected tax rate is $1.20. Additionally, by increasing the recreational bond debt ratio for districts, the public would be liable for more debt incurred by the district, and the public could be taxed at a higher rate as a result of increased debt incurred by the district. The districts in El Paso would be able to authorize recreational debt and charge recreational taxes to the affected public. This rulemaking provides a variety of opportunities for the public to play a role in various district processes. While there may be taxation implications, these are limited in scope and related to specific geographies and recreation. Finally, OPIC notes that if the proposed rulemaking is approved by the Commission for publication, then a formal public comment period would be opened and a public hearing would be offered, therefore providing members of the public an opportunity to engage in the rulemaking process. Thank you, and I'm available for any questions.
Thank you, Jessica. Any questions for OPIC? All right, first I'd like to thank staff for the work on this project. The proposed Chapter 293 rulemaking implements numerous bills from the 87th and 88th Texas legislative sessions impacting water districts, including municipal management districts, municipal utility districts, and levy improvement districts. I believe that the proposed changes are necessary to implement the legislation and are appropriate for publication at this time. Therefore, I'd recommend we approve the publication and hearing on the proposed Chapter 293 amendments and welcome public comment on these. Colleagues?
I'm in agreement.
I'm in agreement, moving them forward.
Thank you. Is there a motion?
I move that we approve the publication of and hearing on proposed amendments to 30 Texas Administrative Code, Chapter 293, as recommended by the Executive Director.
A second?
All those in favor say aye.
Aye.
Thank you. Motion passes. All right, we will move on to new business.
Okay, I'll give everybody a moment to come forward. Okay, new business, item 1 is the consideration of the proposal for decision and proposed order concerning the application by Preserve Hutto LLC for new TIPD's permit number WQ00161-45001. The parties have been notified that the applicant will have 10 minutes of oral argument time. The protestants, who are the City of Hutto and Williamson County Water, Sewer, Irrigation, and Drainage District, number 3, collectively will have 10 minutes of oral argument time. I understand they're splitting it in half. And then the ED and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal because the applicant bears the burden in this matter. So with that, we'll invite Mr. Gregg.
General Counsel, I had some street demonstratives that I'd like to.
Yes, you can approach.
Chairwoman Pop, I am ready to proceed. I don't know if I am
Go ahead.
in direction. Thank you. Peter Gregg, with Greg Law, PC, representing the applicant. Appreciate the opportunity to be before you today and the 10 minutes you've allotted on this issue. This is an important issue. It certainly has implications well beyond our client, the applicant, or these protestants. To be clear, and we say this as respectfully as possible, this PFD is wrong. It is wrong legally. It is wrong factually. Greatest respect for these ALJs, but this PFD is incorrect. The issue framed generally is this: is it proper for an ALJ to determine as a matter of law that an applicant has no right to construct its own facilities based on regionalization? And based on regionalization when, 1, there is no capacity to serve, 2, there is no agreement to serve, and 3, annexation is a prerequisite to serving. The protestants have asserted there's no more logical case to apply regionalization. We would assert to you it is the exact opposite when you take into account those conditions. I'm going to talk about those 3 conditions, but let me frame the issue first, if I could. Page 1 of the demonstrative is simply a recitation of the prima facie demonstration. We established, based on prima facie case, that we met all the state and federal legal and technical requirements. Page 2 of the demonstrative just confirms what the legislature has told us. Regionalization is not a requirement. It's a policy, a goal. As the TCEQ has stated, the requirement to conduct an analysis to encourage that goal. The third demonstrative is simply straight from the crystal clear decision where it articulates precisely that articulation, what the legislature has articulated. The fourth demonstrative page is from the PFD, and it provides 3 conclusions of law. The first 2 conclusions of law recognize that this is a discretionary standard. But then the third conclusions of law says you should deny based on that general policy. We think that is fundamentally wrong. Setting aside that fundamental concept, let's talk about the 3 issues. Physical capability. They had no capability at the time of the application. They had no capability 3 years later at the time of the hearing. They have no capability as I stand before you here today, 4 years after we submitted this application. To the great frustration of our client, the PFD relies on the assertion that capacity, whenever ultimately it becomes available, will be available ahead of our development. That's preposterous. We can't get this development going until we have utilities secured. I think it's pretty well established in the industry, you can't get a loan if you don't have utilities. So we believe that that was a fundamental misunderstanding of the industry in the prerequisites in putting that into the PFD. Ultimately, on this first issue, this PFD would set a precedent that any entity, private, public, municipal, district, could undertake a years-long expansion of its facilities and hold any development project hostage to that expansion, regardless whether they signed up for that project, whether they agreed to partner into that project, and regardless of the substantial delay tied to that project. That's not regionalization. That's not an appropriate application of that goal. Operational capability, second issue. On pages 5 through 7 of my demonstrative, I lay out the ability to serve letter. The yellow shows you all of the contingency on top of contingency on top of speculation on top of trust us that they impose on us and then suggest that they are willing to serve. They are not willing to serve. They have not made any agreement to serve by looking at the face of that letter. Critically, this is what the commission would be handing our client over to if you deny us the ability to construct our own facility. We would be at the complete whim of the district and the developer that controls that district at the complete whim of filling in every one of those gaps in that letter. Third issue, annexation. The PFD creates a new standard on annexation, nowhere found in the law, nowhere communicated from the DS, nowhere otherwise articulated in commission guidance. The bottom line is they try to create a distinction between municipal annexation and this annexation with this district. They do it ultimately and fundamentally based on the proposition that there are no property taxes tied to this annexation. That is wrong. That is factually wrong. It directly conflicts with the facts of this case. Page 8 of my demonstrative lays out just 3 different components of that evidence that clearly establish, and by admission of protestant, that property taxes are in play. Why is property tax issue so critical? If you go to page 3, if you're willing to, of my demonstrative, you will see again that the PFD relies on the absence of property taxes for so much support for its decision. They are wrong on that issue, and therefore their conclusions on that issue are wrong. Annexation will impose property taxes here. There is no distinction to be drawn in this case, nor has the commission ever invited such a distinction between municipality and otherwise. Very briefly on cost comparison, to the extent that we need to get there. As you'll see on page 11, the ALJ scrutinized the issue properly. Conduct analysis of expenditures required to connect the existing facility, conduct an evaluation of what it's going to cost to construct a standalone. And the ALJs, as you'll see on page 11, laid it out. $3 million to connect, 2.6 to conduct a standalone. That's a 15% difference. That's $400,000. That's not inconsequential. I'm not sure how they threw that into the wash. Let me pause there and reserve the rest of my time. I appreciate you allowing me those comments.
Thank you, Mr. Gregg.
Telling me how much time I have left.
Yes. 2 minutes and 40 seconds.
Very much.
Yep. We have Joe Freeland and Stephen Dickman. I don't know which of you want to go first.
Hold on.
Can you make sure that the microphone is on, Mr.?
I'm sorry. Yes.
No, thank you.
Yeah, I represent the water district, in this case, the Williamson County Water, Sewer, Irrigation, and Drainage District Number 3, which I'll refer to simply today as the district. Now, the district is a key party to this regionalization issue in this case because it is the regional entity that wants to provide the wastewater service that the permit applicant proposes to provide through a small package wastewater plant. This is a package plant that would be located right in the middle of an existing well-developed residential neighborhood near the corner of Gaddis School Road and State Highway 130 in Round Rock. The whole point of TCEQ's regionalization policy is to avoid the proliferation of numerous small package wastewater plants when there is a nearby viable wastewater service provider. By applying the regionalization policy in any given case, this helps to reduce the number of wastewater outfalls in the state. It also uses economies of scale to produce lower wastewater rates and costs to customers, and it avoids the operational difficulties and mishaps typical of small package plants. While almost everyone can agree on the wisdom of the regionalization policy, the only problem is that that policy is rarely, if ever, actually used to achieve a reduced number of small package plants. While there may have been good reasons not to have denied a package plant permit in the past under the regionalization policy, this case is the one where it is difficult to rationalize not applying the policy and to deny the permit. There are significant facts in this case supporting the denial of the permit under the regionalization policy. First, the district and the city of Hutto have clearly and repeatedly expressed their desire and their ability to serve the applicant's proposed development. Second, the Forest Creek wastewater plant is located only about 3,500 feet down gradient from the applicant's proposed package plant, and it has a suitable connection point to the Forest Creek plant's collection system located only about 315 feet from the edge of the proposed development. Third, the Forest Creek wastewater plant has had its treatment capacity expanded for the specific purpose of serving the applicant's proposed development and other nearby developments in this rapidly developing area. Fourth, prior to the filing of the permit application, the parties had extensive discussions about having the Forest Creek plant serve their proposed development, and the permit applicant even went as far as seeking to be annexed into the district and obtaining the consent of Hutto and the district to the annexation of the development into the district for that very purpose. And fifth, the costs of connecting the Forest Creek plant are roughly equivalent to, if not less than, the cost of applicant constructing a standalone plant. The ALJ's proposal for decision has a detailed discussion of the cost comparison issue at the PFD pages 37 through 44. So these facts, we think, are clear and convincing that in demonstrating the need to apply the TCEQ's regionalization policy and justifies the denial of the permit. As stated in the PFD, if TCEQ's regionalization policy is not applied in a case like this one, then where there's an existing area-wide wastewater plant that's practically next door to the proposed development that can be used at an equivalent cost to a standalone plant, then as the ALJ states, then the regionalization policy truly has no meaning. That's a quote from the PFD at page 42. So the unique facts of this case will easily distinguish it from any past case where TCEQ declined to deny a wastewater permit based on its regionalization policy. And the unique facts of this case will also serve to mitigate any concerns TCEQ may have about this case serving as a precedent for other permit cases, since few, if any, other cases will have the kind of facts favoring applying the regionalization policy as exists in this case. On the annexation issue, that's one of the main arguments of the permit applicant, is that the district requirement for the proposed development to be annexed into the district constitutes a special condition that equates to denial of service. However, the PFD is clearly correct in stating that whether annexation is a special condition justifying construction of a standalone plant depends on the facts. Because TCEQ's regionalization policy is embodied in guidance documents and not rules, TCEQ is free to interpret and apply its regionalization guidance documents in whatever way it sees fit according to the specific facts of the case. As discussed in the PFD, it was the applicant who originally applied.
That's 5 minutes.
Okay, I'll take a few more minutes, and I believe Mr. Freeland will take the remainder of that, because I wanted to cover this point about it was the applicant who originally applied for the annexation into the district, and that was consented to by the city of Hutto and by the district. It was only after the applicant learned that it would be required to pay the updated impact fees to cover its costs of the Forest Creek plant expansion that the applicant decided to apply to TCEQ for a package plant permit. On the availability of service issue, the applicant has known all along that that plant would need to be expanded, and it was expanded, and it has a permit to be expanded, and is near completion at this point in time, and it will be completely ready to provide whatever capacity is needed at the time the applicant is ready to sell sewer taps. On the comparative costs of the regionalization service versus the standalone plant, I again refer you to the PFD's discussion of that. The ALJ does a good job of laying out all the different costs, and if you include costs that the applicant left out of the cost of building a standalone plant, the costs are roughly equivalent or even more expensive for a standalone plant than connecting to the regionalization plant. So I would just suggest that the facts of this case are very unique compared to other cases, and we respectfully request that you adopt the PFD and deny the permit. I'm available for any questions you may have.
Thank you. Any questions?
Thank you.
Good morning, Chairman, Commissioners, General Counsel, Joe Freeland on behalf of the City of Hutto. I just want to make a quick point about process. Mr. Gregg reiterated this prima facie case, this way you view the draft permit when it comes forward, that really puts the burden on the protestants to overcome whatever the ED recommends in that draft permit. The problem here is the application contained two significant misrepresentations. One, that there was no CCN covering the area where the applicant was going to provide service. Wrong. City of Hutto still has the CCN for that area. Two, that there was no offer from a neighboring utility to provide that treatment service. Again, wrong. As we've all discussed here, the applicant had an agreement with the district. Hutto had consented to allow the property to come into the district. So there was an offer there. Now, why is it important? Had the application contained the proper representations, the applicant then would have had to come forward with a justification as to why the commission should grant a CCN, even though it was in Hutto's CCN, and also would have had to bring forward that detailed cost information, which was not in the application. Now, ultimately, the ED required the applicant to amend the application, but that was only after Hutto and the district had filed. It had been referred to SOA, and Hutto and the district had filed testimony before the case. Now, I think had the ED actually required the applicant to go back and correct the misstatements in the application, which the ED knew because those were brought forward in comments filed by Hutto and by the district, we probably wouldn't be here today. This issue could have been resolved at staff level. I know I'm running out of time, so I just want to make sure Hutto recommends that the commission adopt the PFD and deny the application, and I'm open to any questions y'all might have.
Any questions? No. All right. ED, please.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Ryan Rackwitz of the Environmental Law Division. With me today from the Water Quality Division is Jose Alfonso Martinez. The Executive Director recommends the Commission deny the Administrative Law Judge's proposal for decision and proposed order regarding referred issue A and the draft permit, and issue the draft permit without changes. The Executive Director disagrees with the ALJ's findings of fact and conclusions of law as referenced in their proposal for decision on the referred issue A regarding regionalization. Additionally, the Executive Director agrees with the other referred issues as determined by the ALJs. The ED maintains her position that based on the three components of the regionalization policy, the draft permit is within compliance. First, the application is not within an incorporated city. Second, while the proposed service area is located inside another utility's CCN, the applicant provided information that would be cost prohibitive to connect to the nearby system. Third, there were no domestic permitted wastewater treatment facilities or collection systems located within a 3-mile radius of the proposed facility that were able to provide service at the time. Preserve Hutto demonstrated that it provided the required requests for service to all facilities within a 3-mile radius. The City of Hutto provided a response that it did not have any infrastructure in the area and encouraged Preserve Hutto to contact neighboring cities for potential wastewater service. This email from the City of Hutto to the applicant was a denial of service. Additionally, Preserve Hutto provided sufficient information for the Executive Director to determine that the revised application complies with the TCEQ's regionalization policy. In conclusion, the Executive Director respectfully requests that the Commission reject the ALJ's PFD regarding referred issue A and issue the draft permit without changes. Thank you, and we're available for any questions.
Question for the Executive Director. Eli?
Good morning, Chairwoman Commissioner Gonzalez, and Commissioner Miller, General Counsel and Executive Directors, attorneys, and staff. My name is Eli Martinez. I am Senior Attorney for the Office of Public Interest Counsel for the record. Our office participated in the contested case hearing for Preserve Hutto LLC's application for its new TIPD's permit authorizing up to 990,000 gallons per day of treated domestic wastewater discharge into Brushy Creek in Lake Georgetown. OPIC recommends denial, consistent with the proposal for decision from ALJs Hunzinger and Ludostansky, who found the applicant failed to meet its burden. Under Senate Bill 709, the applicant bears the burden by a preponderance of the evidence. While the administrative record creates a prima facie case for the draft permit, protestants rebutted it here on regionalization grounds, which is a key issue. Texas law through water code sections 26003, 260282, and 26081 strongly favors regional wastewater systems. This policy minimizes new outfalls, ensures facilities have adequate financial, managerial, and technical resources, promotes compliant operations protective of human health and the environment, and safeguards state and local infrastructure investments. Economically, it benefits the public by leveraging economies of scale for lower, more reasonable rates, spreading costs across a larger user base rather than burdening smaller, isolated developments. Even for applicants like Preserve Hutto, regionalization can mean long-term savings, avoiding the high upfront and ongoing costs of building and maintaining a standalone plant, plus access to established, efficient systems that reduce duplication and operational risks, as well as the additional housing units that may be built if an on-site facility is not constructed. Here, the applicant's site is within the city of Hutto's sewer CCN and less than a mile and down gradient from the district's existing facility. Yet the applicant didn't properly request service before applying, as the early 2021 email exchange was not an official service extension request to the city as required, did not contain the proposed facility's capacity, an inquiry for the total cost to connect to their sewage system, and providing sewer services or any additional conditions for receiving service. Further, the evidence shows the district acting for the city was willing and able to serve, had in fact filed a September 2021 ability to serve letter along with an April 22 response to the applicant's request for service, and commenced the imminent expansions to their facility that are already substantially underway to accommodate the additional projected capacity. Applicant asserts that the next step in regionalization analysis to consider whether the permit should be issued based on financial, managerial, and technical factors should not be undertaken because the requirement of annexation, which Preserve Hutto had already requested, imposed a special condition under commission guidance. However, the evidence shows that under the facts of this case, no special conditions were actually required. Limited purpose annexation into the water district here carries only two standard and non-discriminatory conditions: a 2% city sales and use tax, and impact fees to cover the upfront costs of expansion of the existing wastewater system to meet the increased demand from the project. Preserve Hutto is therefore required to either connect to the system or justify their on-site facility by way of a financial, managerial, and technical analysis that demonstrates need. However, the record shows that the costs of connecting to the regional system do not differ significantly enough from building a local plant to outweigh the policy imperative for regionalization. Although the applicant alleges the cost to connect to the district system would be $4.5 million versus $1.5 million to build their own, the evidence shows this projection is highly overstated, and as the PFD concludes, the actual estimated costs of connecting versus building are, quote, about the same per apartment unit. The disparity in projected costs between parties is driven heavily by the applicant's use of a 1.0 LUE equivalency factor rather than the 0.7 LUE factor that the district would actually use to calculate the impact fees for these smaller units, as well as the inclusion of an unnecessary 10% contingency fee, despite the fact that LUE impact fees are a set cost without the need for contingency. Notably, the ALJ's conclusion does not even factor in the transactional costs of acquiring the TCEQ permit and resolving PUC issues, or the lost revenue from the units foregone to create space for the plant. Any remaining minor upfront differences here does not justify the construction of the proposed facility or outweigh the consideration of redundant infrastructure and potential rate impacts for isolated users. In conclusion, OPIC aligns with the PFD. We recommend the Commission deny the application to reinforce the legislature's articulated preference for regionalization's economic and protective benefits, and I'm available for any questions.
Thank you. Any questions for Eli? Nope. All right, Mr. Gregg, you've got 2 minutes and 40 seconds remaining.
Thank you, Chairwoman. First, on the issue of costs, the items that OPIC just went through, those resulted in the $3 million versus $2.6 million. That was the scrutinized amount that ultimately ALJs settled on, accounting for the 10% and the other issues just identified. Second, on the issue, the issue of the quote errors or as he identified the misrepresentations, those were all corrected. They're all corrected timely to the satisfaction of the ED. If you look at the new Air W case out of the 15 Court of Appeals, upholding what y'all did on regionalization previously, you look at the last part of that policy, of that decision, you'll see the 15th Court of Appeals position on the supplementation of applications. Everything certainly was consistent there. We wanted to be a part of this project. It would have been a whole lot easier for us. In 2022, it was not because we suddenly got hit with new impact fees. There were untold number of reasons, all in the record, including not to mention that we're now 4.5 years down the road and still don't have capacity. They continue to talk about having an available plant 3,000 feet away. They don't. They have a plant. They don't have a plant with capacity. They didn't at the time of the application. They didn't at the time of the hearing. They don't today. Last comment. The PFD states, and the OPIC just said it, there are only two conditions that apply. Impact fees, estimated $11,000 per connection, and sales and use tax. Those are the only two conditions the ALJs identified as prerequisites to connect into this system. Look back at the 2021 letter. That simply is not the case. Look at the evidence on property taxes, which are substantial. That's simply not the case. If all we were having to do is pay $11,000 in impact fees, because there are no use fees, no use taxes, if all we were having to do is pay $11,000 in impact fees, we would have never been here, to say the least. If the commission can guarantee us what that PFD is saying, all that is required, we'd be delighted to connect today, assuming that that's going to come on timely, but that's not the case at all. How do we know that's not the case? Because we asked. We asked the district, okay, let us connect on the conditions that the PFD identified, and the answer, of course, was no. Thank you all very much for your attention. We appreciate your time.
Mr. Gregg, I do have a question. Something that was not clear to me given the record, could annexation subject your client to additional property tax burden?
That is the crux of the matter. Absolutely, it will. The evidence shows that it will. And I lay out some of the evidence of that on page 8. Inconsistent with what OPIC suggested, in direct conflict with what the PFD indicates, it is there in the record.
Any other questions? Nope. All right. Thank you very much.
Thank you.
All right, colleagues. Item 1 requires us to consider a proposal for decision concerning an application for a small wastewater discharge permit. The ALJs are recommending permit denial based on regionalization concerns, which was the only disputed issue at SOA. I'm going to stop here and see what your thoughts are.
I've reviewed the administrative record, the PFD proposed order, and I disagree with the ALJ's determination to deny the application solely on the issue of regionalization. The application was referred to SOA on 4 issues: regionalization, nuisance odors, water quality, and public notice. Subsequently, the parties identified regionalization as the sole issue. The ED agrees that the permit should be issued and finds that the applicant met applicable requirements. The state policy on regionalization encourages connection with existing facilities, but the statute does not necessarily require us to deny permits on this sole basis. As past precedent demonstrates, there are exceptions to this policy. We have routinely found that an exception to this policy exists when an existing facility requires onerous special conditions such as annexation. The record is clear that the district would require annexation as a condition of service, which I believe is an onerous special condition. As was pointed out, it can lead to an increased property tax burden. In addition, the applicant provided information that the cost is higher to connect to the existing facility than building a standalone plant. Though I agree with the ALJ that the applicant could have provided better evidence on the cost comparison, the fact remains that I think it would be more costly to connect. Therefore, I think the ALJs erred in recommending denial based solely on the consideration of need and the policy to promote regional or area-wide systems. The applicant established by preponderance of the evidence that the application would not violate applicable requirements, and the draft permit, if issued, is protective of human health and safety, the environment, and physical property. I see no reason to disturb the ALJ's findings on transcript costs. Thus, I believe that the draft permit should be issued and we should adopt a revised order. I have some proposed changes, which I can circulate if my colleagues are in agreement.
Sure.
My comments first.
Yes, sorry. Tanya.
So we take Texas Water Code, Section 26.082, very seriously and have embraced encouraging regionalization over many years by promoting and working with applicants on regionalization issues and solutions. However, I believe denying the permit based on a general regionalization encouragement provision would lead to regulatory uncertainty. Further, in this case, the applicant and protestants provided cost estimates as required in our guidance, and the standalone plant is still the cheaper option. Denying the permit would be second-guessing a private citizen's business decision on the economics of his project. As such, the applicant has met its legal and regulatory burdens, and the permit should be issued by TCEQ. Likewise, I have a motion and propose changes to the ALJ's order that would grant the application, adopt the ALJ's proposed order as modified by my document, and adopt the executive director's response to comments. So I don't know if we want to.
Why don't we take a recess to look at the dueling motions, and we'll go from there.
Hopefully we can harmonize them.
Yes. All right. This meeting stands in recess. We will be back at 10:45. Meeting is back in session. The time is 10:47 a.m. Well, colleagues, I've read through both amendments and motions, and I feel like they are harmonized. While I do believe regionalization is very important, especially given the tremendous growth of this state, it should be appropriate when, it should be pursued whenever it's appropriate. In this case, I feel like the ALJ's got it wrong, and I would grant the permit. Stop and talk to my colleagues.
Yes, I'm in agreement.
I'm in agreement.
Commissioner Miller, do you have a motion?
I would move we grant the application of Preserve Hutto LLC for new TIPD's permit number WQ00161-45001 and issue the permit as recommended by the Executive Director. Adopt the ALJ's proposed order as modified by the document I have circulated from the dais today, and adopt the Executive Director's response to comments to the extent consistent with the Commission's order.
Do I have a second?
Yes, but also pointing out that General Counsel had prepared documents, and they are the same. So I second.
Yes, both documents are the same. There was actually no need to harmonize because they're exactly the same. All those in favor say aye.
Aye.
It passes. Thank you.
Thank you.
All right. Good job, ladies. Right, we'll go to new business 2.
New business 2 is the consideration of the application by the City of Liberty Hill to renew TPDS permit number WQ00150000001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
All right, before us, we have an application for renewal of the City of Liberty Hills wastewater discharge permit that would authorize the discharge of treated domestic wastewater at an annual average flow not to exceed 1.4 million gallons in its final phase. The commission received numerous hearing requests and requests for reconsideration in this matter. Typically, when hearing requests for this type of permit application, the commission considers a two-step analysis that analyzes whether the requester is an affected person and the personal justiciable issues that were raised. However, for renewal applications where the applicant does not seek to change the existing permit, there is initial evaluation of whether there is a right to a hearing under the Texas Water Code, Section 26.028D and 30 Texas Administrative Code, Section 55.201I5. In this matter, I agree with the ED and the OPIC that the city's application satisfies the legal requirements to demonstrate that there is no right to a hearing in this matter. Therefore, we are compelled by law to deny all hearing requests. So that leaves us with a request for reconsideration. In my reading, the RFRs do not provide any new information that was not already considered and adequately evaluated by the ED before she issued the draft permit, so I would deny all requests for reconsideration. If we agree that the hearing request in the RFR should be denied, then I would issue the renewal permit to the City of Liberty Hill and adopt the ED's response to comments. Katerina?
I'm in agreement.
I'm in agreement.
Thank you. Do I have a motion?
I move that we find that there is no right to a hearing on this application pursuant to Texas Water Code, Section 26.028D and 30 Texas Administrative Code, 55.201I5. We deny all hearing requests and requests for reconsideration. We issue the renewal of TIPD's permit number WQ00150000001 to the City of Liberty Hill as recommended by the Executive Director, and that we adopt the Executive Director's response to comments.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. Motion passes.
Okay, item number 3 is the consideration of the application by Nova 368 LLC for new TCEQ permit number WQ 00164880001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, Nova 368 LLC is seeking authorization for a new Texas land application permit authorizing the disposal of treated effluent not to exceed 56,500 gallons per day via surface irrigation of 16.5 acres of public access land in Williamson County. In reviewing the hearing request and the request for reconsiderations in this matter, I find that only Heath Culp, Gail Lasser and Terry Hahn have demonstrated affected person status as to this application. Based on the information provided in the hearing requests, I do not find that the remaining requesters demonstrated a personal justiciable interest in this application. Therefore, I'd recommend denying the remaining hearing requests and referring this matter to SOA for a hearing on 5 issues related to protection of water quality and human health and addressing concerns about odor compliance with the Edwards Aquifer rules and completeness of the application. Further, I believed the hearing duration of 180 days is appropriate and would include a concurrent referral to our ADR program. Finally, I did not find a basis to grant the request for reconsideration. I'll stop here.
I'm in agreement.
In agreement.
All right. Do I have a motion, please?
I move that we grant the hearing request of Heath Culp, Gail Lasser, and Terry Hahn, deny the remaining hearing requests and all requests for reconsideration, refer the matter to SOA for a contested case hearing on the following issues. A, whether the draft permit is protective of nearby groundwater and surface water in accordance with the Texas Surface Water Quality Standards and 30 TAC Chapter 307. B, whether the draft permit is protected of the health and safety of the requesters and their families. C, whether the draft permit complies with the TCEQ Edwards Aquifer rules. D, whether the draft permit adequately addresses nuisance odors in accordance with applicable requirements, including 30 TAC 309.13. And E, whether the application is substantially complete and accurate. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with the SOA's scheduling process and set a maximum duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. Motion passes. All right, we'll move on to 4.
Okay, item number 4 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code, executed between September 1st, 2024 through November 30th, 2025. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yvette Owens, Contracts Work Lead of the Financial Administration Division. I have with me Chris Gobert, Program Procurements and Contracts Manager, and Roger Dubé, Purchasing Supervisor of the Financial Administration Division. We are representing the Executive Director. This item contains the material changes made to contracts and purchases of goods and services between September 1, 2024 to November 30, 2025. Reported material changes include extensions of the contract or completion of work for 6 months or more, or an increase in consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration, and we are available for questions.
Thank you, Yvette. Any questions for Executive Director?
No.
Mary, do we have anyone signed in on this item?
No one signed in.
All right. Garrett?
Good morning, Chairwoman and Commissioners. For the record, I am Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval and issuance of the proposed resolution that acknowledges material changes to contracts for goods and services.
All right, thank you. I'd like to thank staff for assembling this information and bringing it forward to the commission today. I don't have any questions about the entries, and I'm prepared to move to approve the proposed resolution. Colleagues?
I move that we approve the issuance of the Executive Director's proposed resolution acknowledging the material changes to contracts for goods and services as described in the TCEQ Interoffice Memorandum to the Commissioners and Executive Director dated January 28, 2026, in docket number 2025-1704-MIS.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. Thank y'all very much. All right, we'll head to the enforcement docket.
Okay, that does take us to the enforcement docket. It's items 5 through 31, and the executive director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 31. The total assessed administrative penalties are $742,933, with $103,029 deferred, $202,593 applied towards supplemental environmental projects, and $408,751 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Any questions for ED staff? Anyone signed in on this item?
No one signed in to address today on any of the items.
All right, OPIC?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thanks, Garrett. Thanks for all the work that went into preparing these cases and getting them to agenda today. I don't have any questions about these, and I'm prepared to adopt the enforcement items. Colleagues?
Same.
Same.
Do I have a motion?
I move that we adopt items 5 through 31 as recommended today by the Executive Director.
Is there a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes.
Okay, item number 32 is the consideration of the monthly enforcement report, and the executive director's staff is here to present.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Megan Hamilton of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2026 through November. There were 400 effective administrative orders issued, and of those, 46 contain supplemental environmental projects. These orders assessed a total of $7,443,540, with a payable amount of $4,317,044. $2,057,764 to be paid towards supplemental environmental projects. 3,792 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 317 enforcement action referrals have been received. There are 2,977 pending administrative orders, with 1,384 cases that are on the backlog. 164 cases are pending at the Attorney General's office for representation in district court, and 1 judgment has been issued. 1,692 cases are being tracked for compliance. We are available to answer any questions you may have.
Thanks, Amy. Any questions, ladies? Nope. Mary, has anyone signed in on this item?
No one signed in.
All right, Garrett?
OPIC has no comment except to say we appreciate staff's report.
All right, I echo OPIC's thoughts. Thank you for the report. No action is required on this report, so Mary, you can call the next item. Thank you, ladies.
I'll give everybody a moment to switch places. Okay, that takes us to item 33, which is the consideration of the adoption of amendments to Section 30 TAC Chapter 17, tax relief for property used for environmental protection, and to amendments to sections of 30 TAC Chapter 18, voter approval tax relief for pollution control requirements. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Elizabeth Sartain with the Air Quality Division. With me is Amanda Craynock with the Environmental Law Division. For your consideration today is item 33, the Executive Director's revisions to 30 Texas Administrative Code, Chapter 17, tax relief for property used for environmental protection, and Chapter 18, voter approval tax rate relief for pollution control requirements. The rulemaking will implement provisions from Senate Bill 2 from the 86th regular legislative session, fulfill the Commission's statutory and regulatory requirements to review and update the Expedited Review List, or ERL, and Tier 1 tables as necessary, and make additional substantive and non-substantive updates to both chapters. Staff respectfully requests permission to publish the adopted rule revisions. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you for your consideration. We are available to answer any questions.
Thank you. Any questions for Elizabeth? Nope. All right, Mary, has anyone signed up on this item?
No one has signed in on this one.
All right, Garrett? Jessica?
Good morning again. Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. Again, for the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed this rulemaking and respectfully recommends adoption. The purpose of this rulemaking is to amend the Tier 1 tables in 30 Texas Administrative Code Chapters 17 and 18 and to implement Section 44 of SB 2 of the 86th Texas Legislature regular session, which requires rulemaking to correct the title of 30 Texas Administrative Code Chapter 18 to voter approval tax rate relief for pollution control requirements. OPIC notes that OPIC notes that this rulemaking could impact members of the public by affecting appraisal districts that grant and determine the value of tax exemptions. OPIC further notes that there was a public comment period associated with this rulemaking and a public hearing was held by Commission staff. Only one public comment was received, and it was from the Tax Relief for Pollution Control Property Advisory Committee, and the comment was supportive of the proposed revisions. Thank you, and I'm available for any questions.
All right. Thank you, Jessica. Thank you for that summary and for your work on this rulemaking. OPIC, thank you also for your input. I've reviewed this rule package. I see that we had one comment in support of the rulemaking and that no changes were made since proposal. I'm ready to move forward with the adoption. Katerina?
Same.
Do I have a motion?
I move that we approve the adoption of the amendments and updates to 30 Texas Administrative Code, Chapter 17 and 18, as recommended by the Executive Director.
Do I have a second?
I have a second.
All those in favor say aye.
Aye.
Aye. Motion passes. All right, we'll head to item 34 in a second.
Okay. Item number 34 is the consideration of the adoption of amendments to 30 TAC Chapter 39 regarding public notice and 30 TAC Chapter 55 requests for reconsideration and contested case hearings, as well as corresponding revisions to the state implementation plan. The Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Amy Browning with the Environmental Law Division. The adopted rulemaking will adopt new and amended sections of 30 TAC Chapter 39 Public Notice and amendments to 30 TAC Chapter 55 Requests for Reconsideration and Contested Case Hearings, Public Comment, and corresponding revisions to the State Implementation Plan. The rulemaking adoption will implement the required changes to TCEQ public participation rules provided in Senate Bill 1397, the Sunset Bill from the 88th Regular Legislative Session 2023. The adopted rulemaking extends the comment period and opportunity to request a contested case hearing for at least 36 hours for air quality permit applications with consolidated notice, amends notice requirements related to public meetings and contested case hearings for air quality permit applications, and clarifies the Commission's rules to improve the public participation process for permit applications. The proposed rules were published in the August 8, 2025 issue of the Texas Register. A hybrid virtual and in-person public hearing was held on September 8, 2025, and Spanish language interpreters were available. The public comment period closed on September 9, 2025. The rule team did receive public comments, and based on those comments, the rule team made the following substantive changes. In Chapter 55, the definition of personal justiciable interest was not adopted in response to several comments requesting that the Commission decline to adopt that definition. In Chapter 39, changes were made to Sections 39.405, 39.411, 39.412, and new 39.606. Language relating to who may request a contested case hearing on a concrete batch plant standard permit was amended to more closely mirror the statutory requirement. The requirement to keep signs in place was amended to require the signs to remain in place continuously throughout the end of the final comment period. The proposed requirement to increase the size of signs for air quality permit applications was not adopted. The requirement to place hard copies of materials in a local public place was amended to clarify when administratively complete versus technically complete applications are required to be in place, and to clarify that for applications with no requirement for a NAPD, the materials are only required to remain available for the comment period. The proposed change to explicitly require a 30-day comment period for air quality no increase renewals that are in the lowest compliance history rating was not adopted. The proposed new Section 39.606 was amended to clarify requirements for when the agency holds a public meeting and to add an applicability section to be clear what types of applications would be subject to its requirements. Additionally, proposed new Section 39.422 that would have required the agency to provide notice of extensions of comment periods is not being adopted. The proposed requirement for staff emails and notices is also not being adopted. In conclusion, staff respectfully recommends adoption of this rulemaking to Chapters 39 and 55. Additionally, staff requests authorization to make non-substantive revisions as necessary to comply with Texas Register requirements. Thank you, and I'm available to answer any questions.
Thank you. Do we have any questions about this rule package for the ED? All right. Ms. Smith, is anyone signed in on this item?
Yes, we have one person signed in to allow, and we will limit initial comments from speakers, each speaker to 3 minutes, and extend the time if the commission needs further discussion with that speaker. But we have one person signed in, Catherine Guerra.
Good morning, Commissioners. I'm Catherine Guerra with Public Citizens Texas Office. Public Citizen is a nonprofit consumer advocacy organization with over 1 million members and supporters that champions the public's interest in halls of power. We were disappointed that despite numerous environmental advocacy organizations submitting relevant comments that would have strengthened this rule and aligned it with the Sunset Advisory Commission's recommendation, the agency rejected or refuted every comment they provided, and instead, the agency has amended the rule from its original draft to acquiesce to industry. If those comments sound familiar, it is because I delivered them 2 weeks ago during the most recently adopted rulemaking on compliance histories. Unfortunately, they still apply here because the underlying problem at this agency remains. Today, the TCEQ will adopt its public participation rulemaking by rejecting all of the public's participation. This rulemaking was intended to correct a failure identified by the Sunset Advisory Commission, that the TCEQ does not adequately incorporate the interest of the communities it serves. Instead of addressing that failure, this rulemaking reinforces it. TCEQ staff rejected 51 100% of the comments provided by community and environmental advocates. Many were dismissed as outside the scope of the rulemaking. But you have designed a system that pretends to consider public input while structuring rulemaking in a way that excludes community voices. These rule proposals are drafted by the same TCEQ staff that the Sunset Commission found lacked sufficient consideration of the community's interest to begin with. Any comments that address the Commission's inadequacies are summarily dismissed as outside the scope of the rulemaking because the rules are drafted without consideration of the needs of communities across Texas, and this agency has no intention of addressing them. That is not meaningful engagement. That is a closed feedback loop. Public participation in governmental decisions is not optional. It is our legal right and essential to public trust. Consider the imbalance of influence on display here. While 51 comments from community advocates were dismissed, 15 industry comments were accepted, including those that weakened the agency's initially proposed rule and rolled back the provisions that would have improved transparency, public notice, and accountability. That is not neutral decision-making. That is prioritizing polluters over people's health. If this commission's leadership were serious about restoring public trust, this rulemaking would look very different. What we see here instead is an agency that continues to require external oversight and accountability. And we will continue to monitor and document these agency deficiencies and challenge efforts to narrow public participation or create rules that serve industry interests at the expense of the environment and the public. Thank you.
Right. OPIC?
Hi, yes. Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director, Attorneys, and Staff. The Executive Director's Attorney and Staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC has participated in this rulemaking, and we agree with the Executive Director that the proposed rules should be adopted. OPIC understands that this rulemaking is necessary to implement statutory directives contained in TCEQ's Sunset Bill. We note that a public involvement plan was created, and alternative language requirements were followed for this rulemaking. We are strongly supportive of the aims of these rules and appreciative of the direction from the legislature to expand certain opportunities for public participation, as well as provide transparency of our agency procedures. Electronic posting of permit materials such as applications and draft permits allows the public to easily and efficiently access them and will hopefully encourage full and meaningful participation in the decision-making processes of TCEQ. Signposting requirements help to inform citizens of projects in their area, and in the case of certain air quality applications, extending the time allowed for public comment in the event a public meeting is held will allow the public to provide more reasoned and substantive comments for the Commission to consider in its permitting decisions. Likewise, extending the time to request a contested case hearing in the same scenario will allow citizens adequate time to assess information provided during the meeting and decide whether their concerns have been sufficiently addressed or whether they would like to move forward by invoking the hearing process. Additionally, we are supportive of and believe that the efforts to clarify and simplify Chapters 39 and 55 have been successful and will assist the public, including both interested citizens and regulated entities, in understanding and utilizing our rules so that they may operate effectively within their framework. Thank you, and I'm available for any questions.
Thank you, Sheldon. Any questions for OPIC? Nope. All right. I want to first state my gratitude to staff for all the work that's gone into developing this rule package. I understand it was a coordinated effort between many different program areas, and I appreciate our agency's commitment to improving the public participation process. I also want to thank the commenters and the members of the public who submitted written comments, oral comments, or participated in the stakeholder meetings for this rulemaking. I understand that our agency did not adopt all of the commenters' recommendations. In the end, though, I think these rules made some positive strides forward and provided additional clarity to the public regarding TCEQ's public participation process and implement our sunset recommendations in Senate Bill 1397. I'd also like to note that I believe strongly in the importance of public participation. I don't see this rulemaking as an end-all, be-all of public participation, and I'm open to hearing ways that the agency can improve on that front. I invite folks to reach out to my office with their ideas. With that, I would like to move forward with the adoption of this rule package. I'll stop here. Colleagues?
I'm in agreement.
I'm in agreement.
Thank you. Do I have a motion?
Yes. Okay. I move that we adopt the amendments to 30 Texas Administrative Code, Chapters 39 and 55, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
Do I have a second?
Second?
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. All right. The commission will meet in closed session in room 4222, Building F, at 11:40. This meeting stands in recess.
The commission met in room 4222 of Building F for closed session from 11:43 until 12:20 p.m. on item number 36 as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. The agenda stands adjourned. The time is 12:45.